Have you taken steps to protect yourself, your family, and your money? What kind of steps might I be talking about? As an estate planning and elder law attorney, what I'm talking about is making sure you have the right estate plan in place for whatever life may bring. So as an estate planning and elder law attorney, what we're concerned about is planning for the inevitable, which nobody likes to think about, mortality, as well as the possible. Possible means disability, incapacity, none of which any of us want to experience, and hopefully we never will. But that doesn't mean that you don't have the right estate plan in place. So when we're talking about protecting you, the main thing that is important to have are your living documents, your durable powers of attorney for finance, for healthcare, and your healthcare directive, also known as a living will. Why are those documents so important? Because if you do lose capacity, if you don't have these documents in place, the state will step in and you'll become what's called a ward of the state, in a guardianship or a conservatorship, and somebody else is going to be managing your affairs. And it may be somebody that is a family member, or it could be somebody you've never met before, a certified professional guardian, for example. But the state steps in under a court-ordered guardianship and conservatorship. That is a really bad outcome. So not only did you lose capacity, but your family and your loved ones have basically lost the ability to help you, because everything with regard to your legal, financial, health, all of that is subject to the court, to the state. So most importantly, protect yourself while you're alive in case of incapacity. Have your living documents, your durable powers of attorney for finance, for health, and also your healthcare directive. Have you protected your family? Well, having those living documents also does protect your family, because then they don't have to go through having to deal with the state and a guardianship. But when I'm talking about protecting your family, I'm also talking about, do you have the right estate planning dispositive documents in place, like a will or a trust, such that when you pass, your assets will go to those you want them to go to, and if they need protections, that they will have, for example, a trust set up for them. You can set up a trust through a will, you can set up a trust through an existing revocable living trust, but you're protecting them against bad habits, divorcing spouses, maybe they receive government benefits. You want to have the right kind of trust in place for your family, your beneficiaries. And then when it comes to your money, everybody's situation is different. What kind of estate plan do you need to protect your money? Well, do you have a taxable estate? In Washington, that means over $2.193 million. You're going to want to make sure that your estate planning lawyer has protected those assets for your spouse if you have one, and if not, given you advice about how to avoid paying Washington's estate tax. Maybe you have somebody in your family who is on needs-based benefits. Maybe your spouse will need long-term care. You're going to need a will with an asset protection trust, because a revocable living trust won't work. That's how you can make sure that your spouse will never become impoverished, even in the face of long-term care. Everybody's situation is different, and what plan is the right plan for you, what trusts you might need, everything to accomplish your goals, that is what an estate planning and elder law attorney will be able to provide you with. So protect yourself, your family, and your money.